Court General Division. We have the Honorable Judge Gerald Parker presiding. You may be seated.
Thank you. Good afternoon, everyone. This is State Ex Rel. David Esrati versus Dayton Metro Library and Tim Kambitsch, the Executive Director of the Dayton Metro Library. Case number 2018 CV 560. The state wants to introduce who they have at the table, Mr. Peterson.
Thank you, Your Honor. Dayton Peterson, on behalf of the Dayton Metro Library.
Ann Jagelski.
And
We also have Mr. Tim Kambitsch.
for the record, Mr. Esrati, if you want to introduce yourself.
David Esrati, for the record.
All right, thanks, sir. We're here, initially a complaint in mandamus was filed February 1st of 2018. Mr. Esrati, through his attorney, filed a writ of mandamus requesting surveillance footage of Mr. Esrati's ejection from the Dayton Metro Library. Just to put on the record, upon taking the bench in January of 2019, I ordered the unedited copy of the video at issue to be reviewed by the court on April 1st, 2019. Upon review, the court granted Mr. Esrati's motion on July 29th of 2019 with the order that all faces be blurred due to the presence of young children and other patrons at the library. On October 28th, a notice of non-compliance filed by Mr. Esrati pro se indicating missing large segments and gaps and freezes. On December 2nd, the court then held a telephone conference whereby Mr. Peterson, Mr. Esrati agreed that the entire footage of Mr. Esrati's entrance and exit from the Dayton Metro Library would be turned over to Mr. Esrati with all faces of individuals, including children, to be blurred. The court gave the state 6 weeks, if I'm not mistaken, to provide the entire video. That would have been January 13th. The state subsequently filed its notice of compliance on that same date. At this time, the court sua sponte has ordered parties to appear for a hearing to see what, if any, misunderstandings were made from the last telephone conference and to see what has been turned over by the state, what the state has, and also if anything that needs to be turned over in the video. We had preliminary discussions so I could understand as to what there is out there, because the court only reviewed what it received in order to decide, in order to render its decision in July of last year. At this time, what I would like to do is start with the state and get an understanding as to what it turned over, what it has, and how we can proceed from here. Okay, I'll start with you, Mr. Peters.
Thank you, Your Honor. As Your Honor summarized, in July 29, 2019, the order came down from the court for the respondents to turn over 12 total, I'm going to call them cameras. They're basically camera angles or positions the security cameras have within the library, and the respondents have complied with that. This is right. I'm going to hand you here this.
Thank you.
This to the court as well. Tim Kambitsch of the library, Director of the library, has prepared a list of the total camera angles that existed at the time of the incident back in 2017, I believe it was. In total, there are 56 camera angles which depict Mr. Esrati in the library during his 2017 date at issue here. All 56 were supplied to the court for camera inspection. I believe, in my recollection, that it may be that the court asked respondents which 12 depicted the actual incident, Mr. Esrati being accosted and removed from the library. The 12 that were identified ultimately were the ones asked by the court, or ordered by the court, excuse me, respondents to turn over. Respondents have done so. As such, at this time, it is likely accurate that all 56 cameras here show Mr. Esrati in the library to some capacity. Respondents have complied with the order to show the 12 from the court, which I believe show the incident and the subsequent expulsion. To the extent that the court wishes to review again the rest of the records, or to have these other 44 camera angles reviewed and supplied to a certain degree, the respondents are happy to comply with that. All I would say after this point is that respondents have done their best to comply with the court's orders going forward.
Real quick question.
Of course.
In order to provide, how long would it take to provide the other 44 angles?
It's a good question. This diagram here does show the approximate duration of each video. I would not trust my quick math in front of you now, but that gives the court at least a good idea of how many minutes might need to be redacted or how many have been looked at. Do we have? My understanding from my client is that takes about as long as we did already, so I would say 6 to 8 weeks.
About 30 days.
30 days? If the court orders that, we will comply with that.
That being said, is there anything else from the state?
No, Your
All
Honor.
right, Mr. Esrati.
Your Honor, I'd like to thank you for granting this hearing. There has not been a hearing in this case, as you are aware. This is a public records case. It isn't about what the library did on the day in question. It isn't about it's about the public's right to have access to the public record. In Ohio, we have an entire book, the Yellow Book, to help guide citizens in accessing the records, the meetings of public organizations. It is basically the only law I know on the books. It comes with a handbook that's 250 pages to describe 2 pages of laws. And it's the only law where every elected official is required to take a class and learn the law. Okay, so it's there. And people who are directors of public organizations, public servants, they're required to take this course too. I'm not going to sit here and quote it, but I have it here if you want me to quote it. But it says, to ensure that all employees of public offices are appropriately educated about the public offices' obligations under Division B of this section, all elected officials or their appropriate designee shall attend training approved by the Attorney General. A future official may satisfy the requirements, goes on. And what this comes down to is that Mr. Kambitsch and his defense team have demonstrated that they wish to follow the laws. Because as of today, January 30th, 2020, it will be 895 days. That's 2 years, 5 months, 12 days since I requested that the library supply all the video of my visit to the library on August 19th, 2017. My visit was 45 minutes. They have provided a scant 18 minutes and 16 seconds of video. I know that date well because it's exactly 1 year, 1 day after the death of my father. I was taking the day to meditate, to relax, and to think about my father when I was wrongly removed from the library and called a sexual predator by the library's guards. I was harassed on a public sidewalk and then banned from the library for 30 days. To add insult to injury, the library and the county used their unlimited resources to delay the inevitable by denying me access to the complete video record of my visit as asked for and ordered to be delivered to me by this court. Not once, but twice. There's a term for those who fail to comply with the judge's orders. It's called contempt of court. Yet Mr. Kambitsch gets to continue to ignore the law, thumb his nose at a judge. He doesn't have to take any personal responsibility or suffer any personal consequences of his actions. He doesn't lose his job. He doesn't lose respect in the community. He doesn't lose time or pay having to deal with this. His life continues on as if nothing has happened. He doesn't even get his pay docked for the $100 a day fine for the first 10 days that he ignored the law, and then got to add on an additional 885 days of delay without any additional penalty. And he didn't have to pay my attorney's fees, as he knowingly and purposefully breaks the law. And for the record, I am submitting my attorney's fees. Thank you. So that you are aware that attorney's fees aren't exactly cheap. I think there's a reason you went to law school, was to make the big money, and lawyers do that. I am not entitled to attorney's fees for my time or my effort that I have to put into this. We know that the guards lied. The tape we do have supports it. We know it because in an effort to stop the civil rights case, the library admitted they knew it. Since that was a civil rights case settlement and nothing to do with the public record case at hand, I'd like to submit that proof in a letter from their attorney, which summarized the meeting between the director and the plaintiff and the representation on October 3rd, where the library admits I did nothing wrong. Now, this is a public records case. This is not anything to do with this. And on top of that, we know the sticking point the public's right to the public's documents is the foundation of an open, honest government. When public officials stop serving the public, it is up to the citizens to go to the courts, set the record straight. And in this case, it's up to you, Your Honor. I've done nothing wrong. I've done all the proper things. I hired an attorney to make sure I followed the guidelines. Yet the state has run roughshod over a citizen. You do notice that there are 2 attorneys here with umpteen years of legal experience, and there's me fighting for the right of the public to get their access to the records. It's time to fix that. And I ask that you force the defendant to pay attorney's fees, a second remedial fine, and charge Mr. Kambitsch with contempt of court and imprison him until he complies. If you'd like me to break down my entire visit, photo by photo and video by video on this visit, I can. I also have the guards' reports, the internal memos, where on the very day this happened, the very day, Kambitsch closes his email to 6 of his staff. Of course, he wants all of our video footage. That was the last thing he wrote on his emails. And I have those here for you, as submitted to me by them, so they don't need a copy of this, because they full well know it, but it's right there on the front page. Apparently that day, before I wandered into the library for the first time, they were having a civil rights group meeting, and they'd already geared up for extra security and police, and they talked over things, and it's all covered in there. And apparently their employees have lots of time to screenshot my social media about the incident and turn it over. So they were fully aware of what had happened, and yet they've gone ahead and delayed and delayed and delayed. It's 895 days, 2 orders from the court, and I still don't have it. I have to go to federal court because we can't seem to have an agreement over something as simple as a public apology from Mr. Kambitsch. I want to close with a quote from C.S. Lewis. A proud man is always looking down on things and people. And of course, as long as you are looking down, you cannot see something that is above you. Mr. Kambitsch needs to look up at the judge right now, the law, and to me, because he seems to think he's above it all. And I can walk you through this entire thing, and you can see where I was called a sexual predator, where I was harassed on the city sidewalk, threatened with calls to the police, for exercising my constitutional rights and doing nothing wrong. Lastly, I went to see a movie last night. It's called Just Mercy. I hope you've seen it.
And read the book.
And read the book. When the system runs over the rights of citizens in any shape or form, you can say whether it's accusing a man of murder and putting him on death row before he was even in a trial, or when you have a little old lady who doesn't want to give up her seat on the bus. You know, some people say just ignore this whole thing. Okay, they say walk away from this. But it's the small things that add up to the big things. And yesterday, somebody who I've been a friend with for 30 plus years, somebody who's been looked up to in this community, admitted he had made a mistake. And he went to prison for a year. Mr. Kambitsch doesn't seem to fear any of this, or what this is all about. He doesn't seem to understand the importance of our freedom to walk into a public library, to take pictures of a public library, and to not be harassed, hassled, and be threatened by a guard. And last but not least, you know, the library opened August 5th of 2017. This instance was on August 19th, so the library hadn't been open that long. But it's funny, I can go to the WHIO website any day of the week, and I can see pictures of people in the library. No redactions. And one of these is on August 23rd, a mere 4 days after my walk, where a man overdosed in the children's section. Okay? They have video of all that. And last but not least, one other thing, because you are not a video expert. They are obviously not video experts. But what they've handed to us is not what a securities firm would hand to their client to go to court with. What they would hand to us would have date and time stamps. They would actually, instead of sending us those fisheye views, they break it down so that you can see just the section that's pertinent. They have the ability to go through and do that for the whole video. There's no reason to give us those fisheye views. But we can take a look at those if you'd like. I have the entire walkthrough here, and I can substantiate every last bit of what I just said.
That's all right, because the court has already reviewed everything from the issued order from July
Well,
29th. But
There's the fact that there's not 45 minutes of video from the library showing me walk through that. I have the pictures I took, and there's no video of me taking those pictures.
is there anything else, Mr. Esrati?
That's for my opening. Thank you.
Mr. Pierce, anything? Let me first ask, as far as the date and time stamp, again, I'm not going to allow you to argue your case regarding what potential actions you have in federal court, because that's going to be for a separate matter. So we're not going to have a trial about this incident that took place in the library, because I'm here to provide
It's
you
public
with
records.
some public records with the tools that you feel necessary to use in that manner. So I'm really just going to hear from the state as it pertains to the date and time. I'm going to implement my order and entry, and then we're going to go from there. So what, as far as specifically the date and time stamp, I'm not a computer expert. I did want to ask about that. I'm glad you brought that up, because I don't know. It just seems as if whatever you all have, minus the blurring of the faces, which I'm still going to implement that. This, I don't know, assuming however this was created or crafted, or who was given the ability to, I guess, give, I don't know if these individuals pretty much gave their permission or not to be able to do this, so that's something I just don't know. But as far as the time and stamp and the date, how can we proceed with that?
My understanding on the date and time is that when the video is extracted out to be reproduced, it loses the time and stamp on it. That's all I can say on that matter. It's just a function of the system as it's created, as bits are created. In terms of the fish, oh, sorry, thank you.
No, you're fine. Okay, anything else on that?
No, you're not.
Okay, well, whatever you have, I expect to be turned over. The court has issued what it perceived to be what Mr. Esrati requested, which was him being escorted out of the library, and specifically went through those 12 camera footages. At this point in time, the state has 30 days to provide all 56 angles with redaction of the faces blurred. You have 30 days. If not, the court will be finding you in contempt and will be implementing a fine as well. Okay? That's all. All right. Thank you. Thank you.
All rise.
I'll get an entry out here shortly.
Appreciate it.